Hi, I'm Aiden Lerch, and I'm an Associate Overseas Practitioner at Floyd Zadkovich. Today, I'm here to talk to you about using freezing injunctions to protect yourself and your business when bringing a legal claim in today's economic climate.
Floyd Zadkovich, International Commercial Lawyers.
So, what is a freezing injunction? A freezing injunction is a court order which applies worldwide and prevents a person or corporation from using or dealing with their assets. So essentially, it's a really good tool that can be used to freeze someone's assets before a legal claim is made. The claimant can then be certain that there will be assets to satisfy a potential successful claim made against a particular defendant. Now, freezing orders can be made pursuant to Civil Procedural 25.1 subsection 1F as an interim remedy, that is, before the case is brought. Alternatively, they can also be sought whilst a case is on foot pursuant to Section 37 of the Senior Courts Act 1981. However, the elements that must be proven to obtain a freezing order are set out in case law. The leading case on this issue is Alliance Bank and Zorus, which was a 2015 decision. In that case, it was held that in order to convince a court to issue a freezing injunction against another party, the following requirements must be satisfied. Firstly, the applicant must have a sufficient cause of action. This means that the court must be persuaded that the party seeking the order has a valid legal claim that can be sufficiently pleaded. Secondly, the applicant must have a good and arguable case. While there's no requirement for it to be established that the case will definitely succeed, there must be evidence that the applicant's case is a good one. Thirdly, there must be evidence that the opposing party has sufficient assets to meet the claim. This is for the reason that there is no point making an order if there are no assets to freeze. Fourthly, the applicant must demonstrate that there is a real risk of the disposal or dissipation of assets prior to the court's judgment. And finally, the applicant must have made full and frank disclosure to the court. This is the most crucial element in obtaining a freezing order. It means that the applicant is required to present to the court all of the evidence and legal arguments that could undermine its own claim, such as the defences that the opposing party could raise and their likelihood of success. This is so the court can make a determination on the merits of the entire case as to whether imposing the burden of the freezing order on a person or company is justified. When making its decision, the court will also apply the balance of convenience test, which means it will take into account all relevant factors and weigh the likely disadvantage caused to the respondent against the benefit that the injunction would provide to the applicant. Additionally, the applicant will usually be required to provide an undertaking in damages. This means that the applicant essentially makes a binding promise to compensate the respondent if the court later finds that there was no legitimate reason for the freezing order. If the applicant is successful, a freezing injunction will take effect personally against the defendant. It may be made against a third party holding assets on behalf of the potential defendant as well. So these third parties include things like, or people like banks or trustees who hold accounts for the respondent. Now, once the order is made, then the respondent will usually have 48 hours to respond to the order with the full disclosure of all their assets, their value, and location. In some cases, they may be required to sign a document to permit third parties to disclose details about their assets. In serious cases, a receiver may be appointed to monitor their assets. If the respondent ignores the freezing injunction or breaches it by using or dealing with its assets, the respondent can then be held in contempt of court. This is a common law crime and could result in the respondent being imprisoned, fined, or having their assets seized. A knowing and deliberate failure to comply with the terms of a freezing injunction is seen as a serious contempt by the English courts. It therefore is almost always complied with. All in all, a freezing injunction is a particularly useful remedy if a claimant has a strong claim. It allows the claimant to be certain that if it brings proceedings, the opposing party will not be able to dissipate its assets, and there will be ways to satisfy an award made in the claimant's favour. That's all from me today. Thank you for watching, and if you have any queries, feel free to get in contact with anyone from the team at Floyd Zadkovich.